Hello, everyone. Welcome to Transportation Law Lecture 4 on Vigilance over Goods. Recall that extraordinary diligence in the vigilance over the goods tendered for shipment requires common carriers to know and to follow the required precaution for avoiding damage to or destruction of the goods entrusted to it for safe carriage and delivery. It requires common carriers to render service with the greatest skill and foresight and to use all the reasonable means to ascertain the nature and characteristics of goods tendered for shipment, and to exercise due care in the handling and stowage, including such methods as their nature requires. Recall also that the court need not make an express finding of fault or negligence of the common carriers. The presumption of negligence arises as long as there is evidence showing that 1. There exists a contract between the shipper and the common carrier, and 2. That the loss or deterioration of the goods took place during the existence of the contract. Once the above requisites are established, the burden shifts to the common carrier to prove its observance of extraordinary diligence. What is the effect of acquittal? The acquittal of the employee of the common carrier in the criminal case is immaterial to the case for breach of contract. Article 31 of the New Civil Code provides that when the civil action is based on an obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of the latter. Thus, regardless of the employee's acquittal or conviction in the separate criminal case, the same has no bearing in the resolution of the case based on culpa contractual. There is no effect on the presumption of negligence in the breach of contract cases. Extraordinary diligence should be exercised the moment the goods are delivered to the carrier and would only cease after the carrier has actually or constructively delivered them to the consignee or any person with the right to receive them. The goods are deemed delivered to the carrier when the goods are ready for and have been placed in the exclusive possession, custody, and control of the carrier for the purpose of their immediate transportation, and the carrier has accepted them. In one case, the fact that part of the shipment had not been loaded on board the lighter did not impair the said contract of transportation, as the goods remained in the custody and control of the carrier. Also, in another case, the court ruled that the surrender of the bill of lading is not necessary for the discharge of the obligations of the carrier. The common carrier's duty to observe extraordinary diligence over the goods remains in full force and effect even when they are temporarily unloaded or stored in transit. By way of exception, extraordinary diligence need not be exercised over the goods that are unloaded temporarily if the shipper or owner has made use of the right of stoppage in transitu. The right of stoppage in transitu is the right of an unpaid seller to resume possession of the goods at any time while the goods are in transit, and he will then become entitled to the same rights in regard to the goods as he would have had if he had never parted with the possession. The right is available if 1. The buyer of the goods is or becomes insolvent, 2. The unpaid seller has parted with the possession of the goods, and 3. The goods are still in transit. For marine vessels, the ship captain is liable for the cargo from the time it is turned over to him at the dock or afloat alongside the vessel at the port of loading, until he delivers it on the shore or on the discharging wharf at the port of unloading, unless agreed otherwise. Among the carrier's responsibilities are to properly and carefully load, handle, stow, carry, keep, care for, and discharge the goods carried. It is ordinarily the duty of the master of a vessel to unload the cargo and place it in readiness for delivery to the consignee, and this shall be accomplished with sound machinery, competent hands, and in such a manner that no unnecessary injury shall be done thereto. The fact that a consignee is required to furnish persons to assist in unloading a shipment may not relieve the carrier of its duty as to such unloading. The fact that the arrastre operator assisted in unloading the goods will not excuse the carrier. This may just result in solidary liability between the arrastre operator and the carrier. Generally, the goods remain the responsibility of the carrier if they are still in the hands of customs officials. The court believes, however, that the parties may agree to limit the liability of the carrier, considering that the goods have still to go through inspection of the customs authorities before they are actually turned over to the consignee. So the solution of the carrier is to stipulate in the bill of lading that the carrier shall not be liable for any loss while the goods are in the custody of the Bureau of Customs. So that's it for today's lecture. Thank you so much for listening.